A recent U.S. District Court ruling serves as a reminder that more than fair market value is needed to remove an arrangement from scrutiny under the federal Anti-Kickback Statute, the AKS. As I've written in the past for the blog at weispc.com, for example, you can see physician behind bars for referrals, kickbacks, bribes, and mail fraud. The commonly made mistake of believing that structuring a payment or a transaction such that the deal is at fair market value is not the be-all and end-all of AKS compliance. For example, I might pay you fair market value for providing consulting services in regard to my medical device, the Upcode Extractor 2.0, but what if I engage your services as a reward for implanting the device? Or what if the number of consulting days, paid for to the penny, at the amount per day or even per minute opined to by 23 of the nation's most recognized valuation experts, what if that correlates to the volume of your use of Upcode Extractor 2s? Then we've got a problem. In February 2022, the court in a case called Kuo Chow versus Medtronics issued an order denying the defendant's motions to dismiss. The case is a False Claims Act lawsuit brought by a whistleblower relator, Dr. Chow, who alleges, among other things, that the defendants, collectively referred to as Medtronic, engaged in a multifaceted kickback scheme to compensate doctors for ordering a greater number of Medtronic pipeline devices, an implantable device used to treat brain aneurysms. The whistleblower alleged, among other things, that Medtronic maintains a proctoring program through which it regularly pays doctors for professional services. Those doctors were experienced in implanting pipeline devices, and as paid proctors, they taught other doctors how to do the pipeline procedure. Dr. Chow's allegation is that Medtronic systematically and habitually overpays the proctors for their proctoring services as a disguised kickback meant to incentivize them to order more pipeline devices for their own cases. Other alleged circumstances include other alleged overpayments for similar purposes. The defendants argued that Dr. Chow did not specifically allege that the payments exceeded fair market value and moved for a dismissal. The court's response in its order denying the motion to dismiss was that, as had been established by case law, the payer of remuneration violates the AKS whenever one purpose of the remuneration was to induce future referrals or orders, even if the payments were also intended to compensate for professional services. The court also stated that even some fair market value payments will qualify as illegal kickbacks, such as when the payer has considered the volume of reimbursable business between the parties in providing compensation and otherwise intends for the compensation to function as an inducement for more business. The court also stated that, citing previous case law, that neither a legitimate business purpose for the arrangement nor a fair market value payment will legitimize a payment if there's also an illegal purpose, for example, inducing federal healthcare program business. Some takeaways for you. 1. Fair market value is an ingredient in AKS compliance. It's not the whole meal. 2. Even if fair market value is present, the analysis isn't over by a long shot. 3. The underlying scheme, not the ink on the paper, governs legality versus illegality. 4. Every new and every existing financial relationship with anyone or any entity with which physicians and other healthcare providers do business must be vetted or re-vetted in light of enforcement reality immediately.